On July 11, 1958, at 2 a.m., a county sheriff entered the home of Virginia couple Richard and Mildred Loving, forced them out of their bed, and placed them under arrest. Their crime? Interracial marriage. This is the story of Loving versus Virginia and the landmark civil rights decision that would set an important precedent for marriage rights in America. Richard, who was white, and Mildred, who was black and Native American, spent the early morning hours of July 11th in jail. They were tried and found guilty of violating Virginia's Racial Integrity Act of 1924, a series of laws that made race mixing illegal. The Lovings were then given an ultimatum: spend 1 year in prison or leave the state of Virginia for 25 years. Frightened and unaware of their legal options, they moved to Washington, D.C., where their marriage was legal. They raised their 3 children in the nation's capital, financially strapped and isolated from friends and family. 5 years later, they returned to Virginia to visit Mildred's relatives, but were arrested for a second time for traveling together. Inspired by the burgeoning civil rights movement, Mildred decided to fight back. So in 1963, she wrote a letter to U.S. Attorney General Robert F. Kennedy asking for his advice. Kennedy referred the Lovings to the American Civil Liberties Union, who assigned their case to 2 young lawyers named Bernard Cohen and Philip Hirschkopf.
Eventually, after a rigorous process of appeals, Loving v. Virginia reached the highest court in the land. On April 10, 1967, in the United States Supreme Court, Hirschkopf argued that Virginia's miscegenation laws were slavery laws, whose goals were meant to preserve the white race's purity by preventing the mixing of blacks and whites. Cohen insisted,
"They robbed the Negro race of their dignity, and fundamental in the concept of liberty in the 14th Amendment is the dignity of the individual. Without that, there is no ordered liberty."
Cohen explained to the court that Virginia's miscegenation laws violated the 14th Amendment Due Process Clause by making race a deciding factor in the validity of a marriage. Arguing on behalf of the state of Virginia, Assistant Attorney General R.D. McIlwain III maintained that the framers did not mean for the 14th Amendment to apply to marriage, and that marriage was under state jurisdiction, citing regulation of marriages in cases of mentally incompetent people, incest, and polygamy. McIlwain referenced intermarriage, interfaith, interracial, interethnic, a pseudoscientific book published by Dr. Albert I. Gordon, and alleged that interracial marriages were less likely to be successful and resulted in inferior offspring. On June 12, 1967, 2 months after the oral argument, the United States Supreme Court ruled in a unanimous decision to overturn miscegenation laws in the remaining 16 states, making interracial marriage legal throughout the country. Chief Justice Earl Warren declared that,
"Under the Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state."
Subsequently, Loving v. Virginia initiated the increased acceptance of interracial marriages. Although public opinion shifted in the South as well, interracial marriage rates lagged behind those of their northern counterparts. As Alice Leventhal, a black woman married to a white man in Mississippi, explained,
"When Southern women see my husband and I, they herd their children along. Before the case, they used to look at us and say to themselves, 'He may sleep with you, but he'll never marry you.' Now, they feel threatened."
According to the U.S. Census Bureau, there were 2.4 million interracial couples in 2010, which is 16 times the number there was in 1960. The case also helped remove the stigma from mixed-race children, who were considered bastards. They were denied insurance and Social Security since their parents' marriages were not legally recognized. After the case, interracial couples could lawfully get married, and their children received all the benefits to which they were entitled. Another crucial outcome of Loving v. Virginia was the establishment of the basic right of an individual to marry. Drawing on the decision, the 1978 case Zablocki v. Redhale allowed non-custodial parents who were behind on support payments to marry without the prior consent of a court. 9 years later, Turner v. Safley established that prisoners could marry without a superintendent's approval. In the 1999 case, Baker v. Vermont, the lawyers paralleled regulating marriage based on sexual orientation to miscegenation statutes.
Loving versus Virginia basically said who you marry should be a private decision. It should not be based on a characteristic such as race. What many people argue today regarding same-sex marriage is the same principle holds regarding one's sex. Many people back then would cite evidence in the Bible that you should not be allowed to marry from a different race. People said interracial marriages would be bad for children. That's what they're saying today about same-sex marriage.
Following the case, Vermont became the first state to legalize civil unions. It is one of the 9 states that currently allow gay marriage. The Supreme Court is scheduled to hear 2 cases regarding the constitutionality of banning gay marriage. Prior to the Loving case, marriage was regulated by the states, with federal courts occasionally stepping in to resolve disputes between states. Loving v. Virginia was the first case in which the United States Supreme Court overturned a state marriage law. Ironically, the Loving decision established that in family matters, individuals had the right to minimal government interference.
The role of family law has strengthened over time, and it's been particularly strengthened in the area of child support and in trying to get states to work together on some kinds of things, and then also some establishing some constitutional limitations on what states can do.
Although it reaffirmed constitutional limitations on state laws, Loving v. Virginia questioned the methodology used in interpreting the Constitution. During the case, the state of Virginia supported the theory of originalism and argued that the Constitution must be interpreted using the framers' original intentions. McIlwain emphasized that the framers had already debated the issue of miscegenation and purposely left it out of the 14th Amendment, meaning the amendment was irrelevant to the case. Cohen and Hirschkopf insisted,
The 14th Amendment is open-ended and meant to be expounded in light of changing times and circumstances.
Using the living Constitution theory, the Loving decision reignited the debate regarding originalism, which continues today. Throughout her life, Mildred Loving saw herself as nothing more than an ordinary black woman who fell in love with an ordinary white man. Nevertheless, the couple's journey for human rights changed America forever. Today, over 1,000 people flock to New York City every June 12th for the Loving Day flagship celebration to honor the multicultural diversity that the journey brought to us all. As Mildred Loving once said, "I am proud that Richards and my name is on a court case that can help reinforce the love, the commitment, the fairness, and the family that so many people, black or white, young or old, gay or straight, seek in life. I support the freedom to marry for all. That's what loving and loving are all about."